First exception to when you can sue your employer is Labor Code 3706, the illegally uninsured employer for workers' compensation benefits. California law says employers have to provide workers' compensation insurance. That's why workers' compensation insurance is the sole and exclusive remedy. But what happens when your employer fails to secure that insurance? Well, the law says they lose that protection and now you get to sue them. You can have a civil lawsuit. We actually see these cases quite often. There is unfortunately a lot of employers, to save money, they do not secure workers' compensation to protect their employees, and their employees fall victim, in many cases, horrific injuries from some really horrible accidents. In these cases with uninsured employers, the law actually gives a lot of favorable laws for the victim employee. What I'm talking about is when you get a presumption of negligence per se for any OSHA violations or regulatory violations. We also have a remedy to get additional attorney's fees per code. We also have the ability to attach the employer's property, including their personal property, in a pre-judgment writ of attachment, which means you can lock up that property in the very early stages to make sure that they don't go and sell it and hide their assets, to make sure that once you go and get your judgment, you have that money to go after. That's the first exception. The uninsured employer, we see these cases all the time. We know how to do these cases. On the next video, we're going to talk about the next exception, the ratification of assault or concealment of an injury. So stay tuned